4 or 5 hours prior. And if there's no other questions, I would...
Thank you. Our next case will be SQUITIERI versus State. Counsel may proceed. How much time would you like for rebuttal?
I'd like 5 minutes, thank you. Good morning. For the record, my name is Paula Kaufman. I represent the appellant Daphne SQUITIERI. May it please the court, opposing counsel.
Scott, I'd like to talk about the issue as it relates to a jury instruction. Was there a proffered jury instruction from the defense?
No, sir, and I expected to confine my argument to issue 1 today, but I will answer, obviously, any questions the court has.
Are you waiving, then, your argument as to issue 2?
No, sir, I'm relying on my brief as to issue 2, unless the court has any questions.
Then I'm going to go ahead and start with that question. There was no jury instruction proffered to the court.
No, sir, there wasn't.
And how is this issue preserved?
I think it's apparent from the record what defense counsel wanted. He didn't put the actual words in writing, but we know what the court...
How do we know that? I mean, I have no idea what the jury instruction would have said.
Well, I wasn't trial counsel. There is no proffer in the record. I believe I'm confined to what is in the record, so I'm not prepared to propose an instruction today. I do agree that no proposed instruction was offered. Right. And of course the court why do you suggest then that this issue was preserved for appeal? A request for a special instruction was made, and that request was denied. Is that enough? I mean, is it enough to say I'd like a special instruction as to the theory of the defense, or shouldn't there be a specific request where a judge is given a proposed instruction, said this is what we want, as opposed to this is our general theory of what the instruction would say? Yes, sir. I understand the reason for that. It makes it much more difficult for the court to determine whether or not there is prejudice occasioned by the denial of the request. I think we know what we're talking about here, though, because this is so closely intertwined with the suppression issue, issue 1.
Let's stay on issue number 2. You have a situation where the state made a motion in limine to keep you from presenting any evidence as to whether her father had a prescription for these drugs, correct?
Yes.
And then the judge kind of made a compromise decision. Said, I'll let her testify that it was her dad's for purposes of dominion and control, but you can't raise as a defense that she was carrying the drugs for her dad or keeping them for her dad or whatever. You agree with that?
I would.
All right. Do you feel at that time there was a legal obligation, notwithstanding the trial judge's denial, or granted in part of the motion limited denial in part, an obligation to present a jury instruction, even if it could be assumed that the trial judge would deny it based on the trial judge's ruling that had already been made and followed during the proceedings?
My interpretation of the law is that a failure to adequately preserve a jury instruction error may be determined to be the case if no written instructions are actually in the record.
Is this a jury instruction error or a testimony evidentiary error?
I really think it's more of an evidentiary error, yes. They were precluded from presenting certain evidence, and no proffer of that evidence was made either. So I'm completely...
But the evidence was going to be that these were my father's prescriptions, and I was holding the prescriptions. Wasn't that testimony presented to the jury?
Yes, it was.
Well, then what evidence was it that you wished to present to the jury that was not allowed?
Well, there's no proffer of that, and again, I was not trial counsel.
Okay, so we don't know that.
Of course,
so how can that then be an evidentiary issue as opposed to a jury instruction issue?
Well, perhaps it's not.
Well, this is your argument.
and I really wanted to talk about the suppression issue.
Okay, go ahead.
I quite candidly, if this court is going to reverse and give Ms. SQUITIERI another trial, I believe it's going to be on the suppression issue.
Okay, well, then we'll let you talk about that then.
Thank you. Gentlemen, if I take any dog and walk it around any vehicle, if that dog sits down and stares at the vehicle, there's a 50% chance that that alert, and I'm making the quotations in the air sign, that alert will be accurate or positive because there are either drugs in the vehicle or there aren't.
But weren't there other factors involved in this case? It's not simply the dog's alert. I mean, there are other aspects to the case. For instance, this woman was seen at 2 o'clock or so in the morning at a known drug location, going in, coming out from a known drug location, correct?
Yes, and Officer Dillon said he did not have probable cause to believe that there were drugs in the car based on that. He had a hunch, which was wrong.
That probable cause is a totality of the circumstances
yes.
Analysis.
He did not have probable cause until Enzo sat and stared at that vehicle. And the problem that we have with this, basically,
is the officer's testimony as to what constitutes probable cause really or relevant one way or the other?
Well, at this point, it's this court's determination, and I believe it's de novo. Was there probable cause for the search? It's the state's burden to demonstrate probable cause. Arguably, they made a prima facie showing by presenting evidence that this dog was certified and that the handler was certified. However, if that prima facie showing, assuming there was one, wasn't rebutted in this case by the defense as a matter of law, or at least minimally on the facts of this case, I submit a defendant could never rebut a prima facie showing. This dog was less than 50% accurate.
Well,
that's worse than the flip of a coin.
Is there any reason that only the January history records were put in?
Yes, there is.
Is it in the record?
Again, I'm not trial counsel. My understanding is that the records custodian, from my reading of the record, showed up with some records pursuant to a subpoena ducis tecum the day of the trial. The court allowed that suppression hearing to go forward, but I think there was obvious irritation on the part of the court, even in the cold record, that defense counsel had not had an opportunity to look at these records previously, and I've cited in my initial brief that defense counsel basically apologized for not having the records cataloged because he had only received the records that morning.
Did he ask for a continuance or say, Judge, give me...
Yes, he did ask for a continuance, and we did not raise that as an issue, but he did not feel fully prepared to go forward on the motion to suppress.
The subpoena ducis tecum, did it ask for a time frame of records, like the past year, or was it just for 1 month? Or?
I don't believe that's in the record, and I don't know the answer to that.
And is it in the record whether more than 1 month was produced?
I don't believe it indicates what was produced. What they went over...
Wouldn't the subpoena ducis tecum be in the record on appeal?
I don't believe subpoenas are. Notices, subpoenas, I think they're excluded from the automatic record. If I could, before I run out of time, I just want to point out a few of the factual problems that the defense had with this dog. The alert was not within the time taken to issue a citation in this case. The record indicates this stop lasted 2 hours. Enzo wasn't certified to alert on Vicodin, the 2 pills found in the little pill box inside the bag that was characterized by the officer as a purse. Suttles testified outside his area of expertise. He said cocaine, which the dog is certified to alert on, contains opiates, and Vicodin contains opiates. So therefore, by extrapolation, this dog is somehow certified to alert on this drug, which was not one of the 6 drugs that he was certified to alert on. And the difference between drugs is so significant, the chemical composition and the smell, that this dog was actually certified to detect 2 different types of cocaine, crack cocaine and regular cocaine. But somehow this alert is supposed to be valid, even though he wasn't certified to alert on the drug that was found. Suttle's training did not involve chemical analysis or instruction on the odor of drugs. This dog responds to nonverbal cues. In the training that the dog received, the handler was always aware of where the drugs were hidden. Enzo only gets the tennis ball when he alerts. There was at least one instance where the dog failed to alert on 28 grams of methamphetamines. During the testing, 6 packets would be hidden at the same time on a fire truck, and the dog gave the same action, sitting and staring at the fire truck, regardless of the drug that was found. It would be theoretically possible for this dog to have alerted 6 times on one drug, even though he's certified in 6 drugs. Out of 4 searches, this record shows Enzo was accurate 50% of the time or less. At best, he was accurate 5 out of 12 alerts. At worst, 3 out of 10 or 3 out of 12. That's not acceptable. Now, the excuses given are that, well, the drugs were there previously. We might give him credit if there were drugs in that vehicle the day before. Or, we didn't search hard enough to find the drugs. That's not good enough. That subjects any one of us, including myself, to this intrusive behavior by law enforcement. There was no exclusion testing in this case at all. If I could just continue for another minute, and then I'll take whatever reserved time I have. The court misapprehended the testimony in this case, and that was clarified by defense counsel. No exclusion testing in this case at all. It's possible that the dog is reacting to the past presence of drugs, and that's not good enough. You know, an affidavit for search warrant is no good if the evidence is stale. If the affiant says, you know, there were drugs in that house a year ago or a month ago, there's no probable cause to believe that the drugs will be found today at the time the search is made.
What if the affidavit said the day before?
Well, maybe. I guess it depends on the other circumstances. I don't think there's a bright line there. Coleman.
Is it appropriate for us to consider the totality of the circumstances? I mean, because I think the trial judge did indicate a problem. He was impressed with his training. He was unimpressed with his performance in January. And he called it a close call. And I mean, I think the judge did understand the arguments you're making here, and he viewed it as a close call. But is it appropriate to consider the other factors or not?
I'm not sure I understand what the court means by the other factors.
The 2 o'clock in the morning in the drug house.
No, sir. I don't believe so.
That's not, I mean, in other words, could you have a situation where this stop was made for speeding, 2 in the afternoon, no awareness of where the person was coming from, and the trial judge granted the motion to suppress based on Enzo's record, but upheld it in this case? Because there is case law out there that you ought to consider the totality. You don't just focus on the dog's alert.
Not so long ago, since I've been a practicing attorney, this would have been a pretextual stop. I concede that the stop was okay because we have no evidence in the record that the tinting was not invalid.
The question that's being asked is whether the totality of the circumstances, including the time of day and coming from a known drug house, whether the trial court could appropriately consider those factors in determining probable cause.
I don't think that's fair in this case, no.
All right. Thank you.
Coleman, I've got to ask the court to give some guidance in what it means to allow the trial court to determine reliability, for the defense to test the reliability of the dog. And I'm down to a minute and a half, and I would like to reserve that time for rebuttal. Thank you.
May it please the Court, Anthony Golden with the Attorney General's Office representing the state. I'll take the issues in the order in which the court did. The second issue relating to the motion in limine, it probably would have been more properly raised as a jury instruction issue had a proposed jury instruction even been proposed.
Well, but the trial judge here grants the state's motion in limine, and the state is basically saying, well, come on, judge, this isn't a defense.
Well, they didn't really grant it.
That she might be holding these drugs for her father who had a prescription, that's not a defense, and the judge agrees with the state on that. What would the point be? The trial judge isn't going to give a jury instruction. He's already indicated on the record that he's rejected that defense.
Well, first of all, the defense said, we would like to do this, but we have no case law. There is case
Is it
law.
your position that the trial judge's ruling on the motion in limine was correct?
He said, as far as I know, it's not legal for someone to carry another person's prescription drugs for them.
So if your spouse if your spouse has surgery and you pick your spouse up at the hospital and take her to the house, and then you go by the pharmacy and pick up the prescription drugs, the doctor's prescribed the painkiller, and you drive those home to give to your spouse, under the state's argument, that's a felony.
No, it is not. There could have been a jury instruction on temporary control for purposes of legal disposition.
This is different than temporary control. I know there's case law on temporary control where the person is not acting as the agent for the individual who received the prescription. But, pharmacists, the statute provides that a pharmacist can give a prescription to someone who's acting as an agent.
Right.
And the statute doesn't say anything about temporary or permanent. For instance, if you have a parent who's unable to take their own medication, and you pick up the prescription and you provide it to your elderly parent, each day, that may not be temporary. You might be doing that you might have a prescription the last 90 days, and each day you go and give that prescribed drug to your parent. Under the judge's ruling, it would seem that would be a felony.
No, I don't think that was ever properly presented to the trial court in that type of scenario. Of course, we don't have that scenario here.
Well, she did want to testify that this was a drug prescribed to my father, and I keep it in the car in case he needs it.
She was allowed to testify, and so was the father.
But there was no jury instruction given to put that into some sort of context or meaning for the jury, and so it became solely an issue of possession of some sort. I don't know how that.
Well, you're right. There is the statute doesn't specifically address this type of situation. It even mentions that possession includes temporary possession.
So isn't this really an issue that comes down to theory of the defense? And isn't the law on that a defendant is entitled to an instruction on, assuming that the defense is a legitimate defense, that a defendant is entitled to an instruction on their theory of the defense?
If this had been properly presented, he could have got an instruction relating to temporary control.
The judge said there is no legal defense to have a prescribed drug on a prescription in someone else's name, and that's a pretty definitive ruling.
As far as I know, and he said this, that there is no case law for someone to carry another person's prescription drugs for them, and that was basically his ruling. He allowed all the testimony.
And would you agree that's an incorrect statement?
Under very limited circumstances, you can take temporary control for purposes of legal disposition. Yes,
but
you as caregiver.
Shouldn't she be given that instruction, though? Isn't that really critical to her case?
It would have been helpful had defense counsel presented a jury instruction and had case law supporting the type of instruction. But what he wanted the judge to say, that it's a complete legal defense if I tell you my father has a prescription and I'm holding those drugs. And that's not the law, because you'd never get a conviction in this type of case.
Well, why not? The jury could disbelieve what she's saying. The jury could say, well, the father lives, I don't know, whether it's Palm Bay or West Palm Bay, doesn't live where the daughter's living, the daughter's at this, location at 2:30 in the morning, the jury could disregard that.
Well, I think they
and
did.
It would really be in the nature of an affirmative defense, that it would be her burden to come forward and show the existence of the prescription and present this other testimony. But my problem was that you don't even get to the point of the jury instruction, and that's where I was trying to ask Ms. Kaufman. I didn't persuade her of this position, apparently. But we don't get that far because the state potentially walks this judge into error on a motion in limine.
Well, he didn't grant his motion in limine. Granted that everything the defense wanted to present, they presented. They didn't ask for a jury instruction, and they didn't present any law supporting a special jury instruction.
Well, if there's no case law on it, the judge still has an obligation to try to make the best decision he or she can. I mean, there's always a first case on a jury instruction.
Yeah,
and what bothers me is, under the judge's literal statement, I'm ruling on the order in limine, it does mean that anyone who has an elderly parent who brings them their medication is committing a felony, and that's actually contrary to statute, because the statute does refer to dispensing to an agent who does not intend to use the drugs, but it only intends to provide it to the person who's being prescribed the drug. So
a parent could theoretically be prosecuted for picking up medication for a child.
Well, no, I don't think. Well, of course, you're right. The statute is vague. I've read through that possession statute, and it could use some clarification on this type of situation. But there are cases that refer to this exact situation where you have temporary control for purposes of
But the temporary, the one case that dealt with temporary was the person who was prescribed the drugs was an adult and was unaware that the defendant was holding the drugs. The person said that it was someone else's drugs, and they took them so that their kids couldn't get a hold of them.
Right.
So the person was not acting as an agent for the patient, if you would. I mean, was there a jury question? Was there a question from the jury on this issue?
I don't recall if there was or not.
Neither was.
Perhaps Ms. Kaufman will remember. I don't feel that this issue was properly preserved. I don't think the facts of this case would warrant the instruction in any event. Under your scenario, yes. But under this, we have her father saying, I've lived in New York for months. I haven't been taking this prescription for months. She has these pills mixed with her pills in her purse, and she's saying she has them for her father, and it was to dispense them to him.
But isn't that a question of the weight of the evidence and whether the jury chooses to accept her explanation? And the jury could have rejected, because initially she said it was my prescription. Well, she didn't say it was my prescription. She had said it was her prescription, and then she says, well, no, it's my father's prescription. The jury could find that they don't believe her.
No, I think they did.
But shouldn't they be given an opportunity to have this presented in some fashion?
They're given the standard instructions on possession, but like I said, they're kind of vague on this type of situation. I think had this been handled better in the trial court, there would have been a special jury instruction to fit this situation. But under the facts of this case, it would be a tough road to hoe to convince the jury that these were being...
Well, that might be.
Let's talk about Enzo the dog. It struck me that in training, Enzo was like a basketball player, free throw shooting percentage of 100%, but in the game time, for January, it seems like Enzo might arguably was shooting between 30 and 50%. What's your response to their argument?
Yes,
the judge... I think that any dog that makes even 30% of his foul shots is doing quite well.
Well, the judge did say that he needed some addition. He thought that Coleman... By the way, the dog was properly trained and certified, and all that was introduced. And so... but the bottom line is the judge didn't understand what a false alert, how he should analyze these maintenance logs to determine the reliability of a dog. For example, in this case, let's say the defendant is leaving a meth house gets in a car, has tinted windows, is stopped by a police officer, and the dog alerts. Well, a dog alert could be to the odor of methamphetamine on her clothing. It could be to the odor of marijuana in the house. It doesn't mean that because, let's say there was no pills in the car.
Okay, so let me ask you this hypothetical. There are a teenager or young adult borrows mom's car and with some friends, and perhaps they smoke some marijuana in the car. A week later, mom is out driving the car, and they bring a dog, and the dog alerts. Is that probable cause?
The dog will alert, yes. That constitutes probable cause under Coleman, assuming he's properly trained and certified. There may be flakes of marijuana in the car, there may be residue, and a dog will alert to that type of
Assuming
odor.
that there is no residue?
But when the police search, they're not going to find any drugs, and that's going to be listed as a false positive and say this dog is wrong. Well, the dog was right, but you didn't find any drugs, so the logs could look worse than they actually are.
Wouldn't you agree, though, that most law enforcement officers would say it's not really a false positive, Judge? The drugs had been there because my dog's well-trained, experienced, and it keyed off a drug, trained for marijuana, cocaine, whatever. So the proper assumption would be that the drug had been there, even though it's not there at that time. And isn't that really an escape mechanism for law enforcement to use?
Well, to answer your question in this case, he did say all that. And he said, I've worked with this dog on many occasions. He's an amazing dog. He's properly trained. We've had a lot of success with him. So he could say that he was always right, but what I'm saying is the maintenance logs or the record of the dog's performance is deceptive. And it's...
Well, what's the relevance of the maintenance log if they could always, any false alert, if you would, could always be called a correct alert, but the drugs are no longer there? What's the purpose of the maintenance log then?
Well, I think it's another factor. Well, I think what Coleman says is once we've shown that the dog is properly trained and certified, then you can bring up the logs to demonstrate that the dog is sometimes wrong.
And what else can they do then? They bring that up here, and they show that this dog is wrong over 50% of the time in actual...
Well, not necessarily wrong.
There are no drugs. It's a false alert over 50% of the time. What more is it that you expect the defense to do?
It's a factor that the judge considers in taking the whole situation into determining probable cause. Where the car was coming from, who was driving, the time of day, all of that. You could go into each specific prior incident where a drug was not located inside the vehicle and explain why, if it had enough time to do enough discovery on that.
But accepting the state's position, if you took the January records and 10 times the dog alerted and 10 times drugs were found in one situation, in another situation 10 times the dog alerted and 2 times drugs were found, but the state's position is that just means on the other 8 occasions drugs had been there but were no longer there.
Well, we don't know. It's something the trial court judge would weigh.
So the trial judge should reject your argument to some degree.
He asked for guidance is basically what he said in his order.
Well, what would you suggest the test be? If we were to the judge did ask for guidance, what would you suggest the test be?
Well, the defense could bring up each prior incident where there was a false positive and ask the officer to explain the circumstances and why it was a false positive.
But you're just talking about speculation. I mean, all the officer can say is that just suggests the drugs were there on a prior day, or that we didn't search long enough. I mean,
well, both of these officers said this.
You're asking the defense to prove a negative, if you will.
Well, they have to prove something here because both officers testified this dog is great, he's properly trained and certified, and the judge said he's an amazing dog. So, I mean, everyone, at some point, the burden shifts.
Okay, but if we were to provide, the trial judge said, I hope the Fifth provides us with some guidance.
Oh, I don't...
What guidance you know, you're the advocate here. What guidance should this court provide to the trial judge?
You can tell him to take what he's got and start weighing it, because I don't think you can give him absolute, because there is a degree of speculation into why there was not why the dog alerted when the drugs weren't in the car. It's just, it's a difficult question. I understand his problem, but I also think that he's asking you to do something rather difficult to accomplish.
Your time's up. Thank you.
Very quickly. Yes, there was a jury question. The jury wanted to know if there was any time limit on Ms. Squitieri's authorization by both her father and the pharmacy to pick these drugs up. You can't
How was
count.
that answered?
I believe the court indicated that the jury would have to rely on its own recollection. I don't have that right here where I'm looking at my brief. But that question was asked. They were troubled by that.
Are you seeing this more as a jury instruction issue yet?
I beg your pardon?
Are you seeing this issue as more of a jury instruction issue yet?
Yes, sir. You can't count the false positives. What do I think needs to be changed? The testing. There needs to be exclusion testing. They need to test one drug at a time, and if the dog is going to be certified in 6 drugs, then an alert only counts if they find the drug that he is certified to alert on, and this drug, he was not certified.
Well, you would agree that if there had been a large amount of drugs in the car the day before and the dog alerted on it, it's really not a false positive.
Well, it depends. I mean, in the hypothetical that Judge Cohen gave, we know that marijuana was smoked in the vehicle 5 days before. Then we know the dog is right, I guess. The problem is, in the field, we don't know what happened a day before or a week before. Law enforcement doesn't have the benefit of that knowledge. It's not fair to count a false alert. I would beg the court to author a decision in this case and to reverse on either issue. Thank you.
Thank you. Thank you both.